Hello everyone, in this video I will discuss with you Criminal Procedure Code MCQ which will help you in your upcoming examination. So let's start. First question is, Code of Civil Procedure 1973 came into force on which date? And answer is 1st April 1974. Next question is, the Code of CRPC of 1973 is divided into, so how many chapters and sections are there? And total chapters are 37 and sections are 484. So answer is D. So these are basic questions which are asked from which may be asked from every subject, maybe CPC, Indian Evidence Act, IPC, etc. Third question is, the Code of Criminal Procedure 1973 extend to, and answer is to the whole of India except to the state of Jammu and Kashmir. Next question is relating to assertion and reason. Subject to some exception, the provision of Code of Criminal Procedure are not applicable to tribal areas in undivided Assam. These areas enjoy special status like the status of Jammu and Kashmir. So which is the correct answer out of these? Here A is true but R is false. So subject to certain exceptions, provisions of Code of CRPC are not applicable to tribal areas in undivided Assam. Next question is, which of the following is correct answer? Provision of CRPC do not apply to state of Jammu and Kashmir. All provisions of CRPC do not apply to the state of Nagaland. So here the correct answer is A. Provisions of CRPC do not apply to state of Jammu and Kashmir, and only some provisions are there which do not apply to the state of Nagaland. So second will be incorrect. Next question. The provisions of CRPC 1973 other than those relating to the chapter 8, 10, 11 shall not apply in which of the following, and answer will be the state of Nagaland. This is also important. The name of the chapter 8, 10 and 11 shall not apply to the state of Nagaland. Next question. Consider the following statement. CRPC extend to whole of India except to the state of Jammu and Kashmir. Provisions relating to chapter 8, 10 and 11 under CRPC shall not apply to state of Nagaland and to tribal areas. CRPC 1973 came into force on 25th January 1974, and chapter 2 of CRPC deal with the constitution of criminal court and offices. And out of these, how many are correct? That has to be answered, and here correct will be first and fourth only. So these MCQs were relating to application of CRPC. Now next question is, complaint under section subclause D can be, answer will be oral or written. Complaint can be oral or written. Next, complaint means, answer will be B. Any allegation made orally or in writing to the magistrate. This is important, that complaint is always made to the magistrate, not police officer, to take action against known or unknown person who has committed an offence. So for the complaint, it is not necessary that the accused must be known or the person against whom the complaint has to be made, that has to be known. So that person may be known or unknown. Next question. Complaint may relate to, answer is, it may be related to cognizable offence or non-cognizable. So C will be the correct answer, while FIR is always related to the cognizable offence. Next question. The most essential ingredient of complaint is, answer is an allegation of an offence with a view to take action. Next, which of the following has been specifically excluded from the definition of complaint under section 2 subclause D CRPC? Answer will be the police report. So police report is not included in the complaint. That is provided under section 2 subclause D. Which of the following statement does not come under the definition of complaint under section 2 subclause D of CRPC? And here the correct answer will be D option. Police report made after the investigation which discloses the commission of a cognizable offence. Next question. Inquiry under Criminal Procedure Code is conducted by, answer is magistrate or court. So inquiry is always conducted by magistrate or court, not by police officer. Next, point out the incorrect response under CRPC. Answer will be incorrect inquiry is conducted after the framing of charge. This is incorrect point. So B is the incorrect point, because inquiry is always conducted before the framing of charge and trial commenced after the framing of charge. So if you want to know the difference between investigation, inquiry and trial, then I will provide you the link of the video in the description. You can watch that video. Next question is, which of the following statements are true? And out of these, true statement is B. Inquiry means every inquiry other than a trial conducted under CRPC by a magistrate or court. Next question, section 2 subclause H of CRPC define the term. Answer is investigation. Next, investigation under the CRPC is conducted by police officer only. The definition clause of CRPC actually is very important. The definition of investigation, complaint, cognizable offence, non-cognizable offence. So you must read that definition clause once from CRPC. Next question. In a non-cognizable case, the police has the authority. Answer is C. Neither to investigate without the order of the magistrate, nor can arrest the accused without warrant. Next question. Permission to investigate into a non-cognizable offence can be granted by, answer, magistrate having jurisdiction to try the case. This is important, that permission can be given only by the magistrate who have jurisdiction to try the case, not by any other magistrate. Next question. Under CRPC, the nature of the non-cognizable offence is, answer is bailable and simple. So generally non-cognizable offence are those which are bailable and simple offences. Next question. Under which section of CRPC the term offence has been defined? So offence has been defined under section 2 subclause N. Next question. Public prosecutor under section 2 subclause U of CRPC means and includes, and here answer will be C, both A and B. So let's read both. Any person appointed under section 24 CRPC or any person acting under the direction of public prosecutor. So both will be included there in the definition of public prosecutor. Next question is, summon case means a case relating to an offence punishable with, answer is imprisonment for a term not exceeding 2 years. This is very important. This is defined under section 2 subclause W of CRPC. Next, summon case means, answer is A, a case which is not a warrant case. Next definition is relating to victim, is defined in CRPC under, answer is section 2 subclause WA, and this definition was added in 2009. Next question is also relating to the same. Which of the following is not correct in respect of the term victim under section 2 subclause WA of CRPC? Answer is, it does not include guardian but legal heir. So this is not the correct, because it actually included guardian as well as legal heirs. Next question. As per CRPC Amendment Act 2008, which inserted clause WA in section 2 of CRPC, defining victim as a person who has suffered any loss or injury caused by the reason of the act or omission for which the accused person has been charged, includes victim's guardian and legal heir. This definition is actually very important. This was added by Criminal Procedure Amendment Act 2008, but it was effected from 2009. So it came into effect in 2009, and every word of this definition is very important, because victim include a person who suffered any loss or injury caused by the reason of the act or omission for which the accused person has been charged, and it includes guardian and legal heir both. Next question. Which of the following section of CRPC provides sentence of imprisonment by the court of magistrate in default of fine? Answer is section 30 subclause 1. Next question. Under IPC, when the offence is punishable with both imprisonment and fine, a sentence of imprisonment for non-payment of fine shall not exceed, answer is 1/4 of the maximum term of imprisonment fixed for the offence. Next question, imprisonment in default of payment of fine can be awarded. Answer is B, in addition to the substantive sentence imposed. Next question, a magistrate convicts an accused of theft for 1 year imprisonment and 1000 fine. Maximum punishment for which accused can be sentenced to imprisonment in default of fine shall be. Answer will be 9 months. So 1/4 of 1 year will be so correct answer will be the 9 month, and 9 month is 1/4 of 3 years, which is the punishment provided for the theft under IPC. So the punishment for theft is 3 years and 1/4 is 9 months. So only up to 9 months can be imposed in default of payment of fine. Next question, if an accused at one trial is convicted of and punished with imprisonment in 2 offences under section 31 CRPC, the imprisonment in the absence of any specific direction of the court will run. Here answer will be A. Consecutively. So if there is no specific direction that how the sentence will run, so it will run consecutively. Next question, in case of conviction of person of several offences at one trial, in no case such person be sentenced to imprisonment for a longer period than, answer is 14 years. This is also provided under section 31. Next question is relating to the match the following, and here special metropolitan magistrate can give punishment up to imprisonment up to 3 years or fine. CMM, chief metropolitan magistrate, can give punishment up to 7 years or and fine. Next, judicial magistrate second class can give punishment up to imprisonment up to 1 year or fine up to 5,000 rupees. And assistant session judge can give punishment up to imprisonment up to 10 years or and up to fine. So this is very important. Next question is under CRPC, which one of the following court can try a murder case? Answer is session judge, because in death for murder cases the death is the maximum punishment which is provided under IPC, and session judge jurisdiction to punishment is unlimited. It can grant also the death penalty subject to the confirmation of the High Court. Next question is, which of the following court can try a case punishable with life imprisonment? Answer is session judge. So out of these, session judge can try a case in which the punishment is life imprisonment, because magistrate first class jurisdiction is not to give life imprisonment, and also CJM can grant only punishment only up to the 7 years imprisonment. Next question, which of the following sections of the CRPC prohibit the male police officer from touching the person of a woman while making her arrest? And answer is proviso to section 46 subclause 1. This is also important, where the procedure of arrest has been provided under section 46 CRPC. Next question, which of the following statement is wrong? If a person foreseeably resists the endeavor to arrest him, the police officer may. Answer is cause the death of such person irrespective of the offence he has committed. So this is wrong option here. Police officer cannot actually cause the death of the person. Only in some cases it is allowed, not in all the offences. Next question, save in exceptional circumstances, no women shall be arrested after sunset and before sunrise, and where such exceptional circumstances to arrest exist, the women police officer shall obtain the prior permission of the following. Answer will be the judicial magistrate first class. This is also very important. Next question, power to search a place is provided under section 47. Under which provision of CRPC procedure it is mandatory for the police officer to inform the person arrested the ground of the arrest and right to bail if the offence is bailable? Answer section 50. Next question, indicate the correct statement regarding the rights of an arrestee. Here the correct answer is C option, first, second and fourth. A person arrested without warrant has a right to be informed of the particular of the offence for which he is arrested. Have a relative or friend named by him to be informed about his arrest. Be medically examined by a medical officer. Next question, section 50 CRPC provide that every person arrested without warrant shall be informed of a ground of arrest and right to bail. If the arrest is made for a bailable offence, what is the effect of non-compliance of these provisions? Answer will be C. It shall render the arrest and detention of the person concerned illegal and shall enable the person arrested move for habeas corpus to obtain his release, because he must be informed about his ground of arrest and right to bail if it is a bailable offence, and these provisions are mandatory in nature, that is section 50 is mandatory in nature. Next question, under section 53 CRPC examination of accused by a medical practitioner is at the request of police officer of, answer not below the rank of sub-inspector. Next question, which of the following sections of CRPC provide that the person of a female shall be examined only by or under the supervision of a female registered medical practitioner, and this is provided under section 53 subclause 2. Next question, which one of the following group of sections of CRPC deal with the proclamation and attachment? Answer section 82 to 86 deals with proclamation and attachment. Next question, under which sections of CRPC a proclamation for person absconding may be issued? And this is issued under section 82. Next question, period of appearance for proclamation issued under section 82 CRPC it is not less than, answer is 30 days. Next question, a proclamation under section 82 CRPC can be issued against a person against whom an arrest has been issued. Thus a proclamation can be issued against, answer will be all of the above, against accused offender, surety or a witness. Next question, penalty for the non-appearance in cases where a declaration has been made under section 82 subclause 4 of CRPC pronouncing a person a proclaimed offender is provided under, answer will be section 174A of IPC. So if the person who is a proclaimed offender in CRPC, if he does not appear, so the penalty will be under section 174A IPC. Next question, under which section of CRPC a person who is avoiding execution of a warrant may be proclaimed offender? Answer is section 82. Next question, a warrant of arrest and a proclamation under section 82 CRPC issued simultaneously and later a consequential order of attachment under section 83 was also issued. What is the legality of these orders? Answer, the order under section 82 is illegal and improper, vitiating the consequential order of attachment. Next question, under which section of CRPC an order from attachment of property of person absconding may be passed at any time after the issue of proclamation? Answer will be section 83. So attachment order is passed under section 83. Next question, under section 83 subclause 1 of CRPC the court may order, answer, attachment of property of person absconding after proclamation. Next question, attachment of property of person absconding can be, answer, issued simultaneously with the issue of proclamation. Next question, in order to compel appearance of a person who is absconding in spite of a warrant of arrest being issued against him, his property may be ordered to be attached simultaneously with the issuance of a proclamation under section 82 of CRPC, provided that the court is satisfied that such person is, answer is I'll give you the answer of this question 25 in the description and in comment box, so please refer the comment box for the answer of this question. Next question is, for what offence a convicted person may be asked to execute a bond for keeping peace? And answer is for all of these offences: unlawful assembly, writing, and criminal intimidation. Next question: what is the extent of the period of security which a court can order under section 106 CRPC? Answer is not exceeding 3 years. So under 106, extent of period will be 3 years. Next question: which of the following magistrate can make an order under section 107 CRPC to a person who is likely to commit a breach of the peace or disturb the public tranquility to execute a bond for keeping the peace? Answer will be executing magistrate. And under section 107, the time period is only 1 year. Next question: under section 107 of CRPC, executive magistrate can obtain bond from a person if the person is likely to commit a breach of peace. Next, in proceeding under section 107 CRPC, executive magistrate may require to execute a bond for keeping the peace for such period not exceeding 1 year. Next question: security for good behavior from person disseminating the seditious matter is taken by a magistrate under section D, section 108 CRPC, and this is also for 1 year under 108 CRPC. Next question: executive magistrate can order to execute a bond as security for good behavior from suspected person for a period not exceeding. Answer will be 1 year. So from suspected person it is 1 year under section 109 CRPC. Next question: who has the power to require security for good behavior from suspected persons? Executive magistrate. Next question: the bond under section 109 CRPC as security for good behavior from suspected person can be executed for a period not exceeding 1 year. Which of the following sections of CRPC provide as to the security for good behavior from habitual offenders? And this is provided under section 110, and this is provided for 3 years. Which of the following magistrate is authorized under section 110 CRPC to require security for good behavior from habitual offender within his jurisdiction? Answer is executing magistrate. Next questions are relating to the jurisdiction of the criminal courts in inquiries and trials. Ordinarily, place of trial is answer where the offence has been committed. Next, a minor girl lived with her father at Indore. She became intimate with the accused and ran away with the accused from Indore to Bhopal in a taxi. After some time, they eventually settled in Mumbai. An offence of kidnapping may be tried at which place? So answer will be at any place mentioned above, because kidnapping is a continuing offence. So at any of the place from Indore, Bhopal or Mumbai. Next question: X send an email to Y from Delhi threatening Y that certain photographs showing Y in a compromising position with a woman shall be posted on the net. If Y does not pay 1 lakh to X, Y accesses the email at his office in Kolkata. The offence can be inquired into or tried by a court at. Answer will be A and B, Delhi or Kolkata. So it is relating to. Next question: an offence of theft can be tried by a court under whose jurisdiction? Answer will be D, any of the above. Where the theft has been committed, the stolen property is found in the possession of thief. The stolen property is kept by accused knowing it to be stolen. So at any of these places. Next question: section 183 CRPC. Answer does not apply to voyage on high seas. High seas पे apply नहीं होगा. So next question: when there is a dispute between two courts relating to the exercise of jurisdiction in a criminal matter and said court are under subordination of the different high court, the matter shall be decided under section 186 CRPC by which? Next answer will be the high court within whose area the proceeding first commenced. Now these are some of MCQs relating to charge. Question is: for every distinct offence of which the person is accused, there shall be a separate charge which shall be tried separately, and this is general rule which is provided under section 218. And charge is defined under not defined, basically relating to charge, the provision has been provided under section 2 subclause D of CRPC. Next question, for every distinct offence for which any person is accused, there shall be a separate charge. Where is the exception of this rule? Answer is section 219, 220, 221 and 223, because these are relating to the joinder of charges and joinder of trial, joinder of accused in trial. Next question, which of the following is not correctly matched? Answer will be D, contents of charge, and D, trial more than one offence, section 218. Next question, under section 219 of the CRPC, offence of same kind means, answer will be C, when they are punishable with the same amount of punishment under the same section of IPC or any special or local law. Next question, dash offences of the same kind within 12 months can be charged together as per the provision of section 219 of CRPC. Answer will be 3 offences of same kind. Next question, when a person is accused of more offences than one dash committed within the space of 12 months, he may be charged with and tried at one trial for any number of them, not exceeding 3. Here the correct option will be D, of same kind. Next question, if a series of acts are so connected together as to form the same transaction and more than one offence is committed by the same person, then he shall be charged with every such offence and try at one trial for all such offences. And this is provided under section 220 CRPC. Next question, when at this stage of framing of charge the session court feels that the case is not exclusively triable by it, then it may, answer will be frame the charge and transfer the case to the CJM or magistrate first class. Next question, A is accused of an act which may amount to theft or receiving stolen property or criminal breach of trust. A is only charged with theft. It appears that he committed the offence of criminal breach of trust. Answer will be, he may be convicted of criminal breach of trust though he was not charged with the offence, and this is provided under section 221 of CRPC. So these were some MCQs of Criminal Procedure Code. I hope this video will help you. Thanks for watching.